Hello everyone and welcome back to Straight Down the Middle. I have had so many people asking me what the heck is going on with the young thug case down in Georgia that I decided to do an episode about it. But here's the thing. I'm not going to take sides in this case. I'm not going to say lock him up or let him out. And that's for two different reasons. First, because I don't know the facts. After all, that's what trials are for. Second, because that's not what I do on this show. I'm going to try to explain the case to you, because there are all kinds of crazy things going on. Like, for example, the fact that the judge just sentenced the lead defense lawyer to 20 days in jail. So I'm going to try to explain the case to you so you understand it better and understand some of the legal issues better, maybe even better than some lawyers do. That's my goal, and I'm going to try to do it as I always do without taking sides. So let's jump right in. So first of all, who is Young Thug? Okay, as most of you probably know, he's a rapper, famous rapper, Grammy Award-winning rapper. Real name, Jeffrey Lamar Williams, and he's on trial down in Georgia, Atlanta, Georgia, for some pretty serious crimes. Here's something that I'm hearing a lot from people. They say, Professor, I feel like I've heard about this case for over a year. Is that true, and is that normal? Well, it is true, and it is not normal. This trial's been going on for a year and a half already, and it looks like it's going to take 3 years. If it does, that'll be the longest criminal trial in the history of the United States. Jury selection alone in the case took 10 months. That not only broke Georgia's record, that probably broke the record for jury selection in any case in U.S. history. So what's going on? How come it's taking so long? Well, there are many reasons, but here's one main reason. Because the prosecution's witness list has 400 people on it. You got 400 witnesses. Of course a trial is going to take years, and of course jury selection is going to take forever too. How come the prosecutor wants to call 400 witnesses? What's going on with that? Well, what's going on with that is that this isn't just a little case against Young Thug on a couple of different criminal counts. No, this is a massive RICO conspiracy case, originally brought against 28 defendants, including Young Thug. So what's RICO? RICO is the name of a statute. It's short for the Racketeer Influenced and Corrupt Organizations Act. It was originally passed by Congress 50 years ago, around 1970. But after Congress passed its RICO statute, a number of states, about 30 states, passed little mini state RICO statutes too, and Georgia was one of them. Young Thug is not being prosecuted in a federal court, in a federal prosecution. He's being prosecuted in state court in a state prosecution under Georgia's state RICO statute. Now, why does a prosecutor bring a RICO case with 400 witnesses? Why are they going to do that? Well, because RICO prosecutions are very advantageous to the prosecutor. Let me tell you why. RICO allows the prosecutor, I'm simplifying a little bit, but this is basically how it works. It allows the prosecutor to go after a whole criminal organization and everybody who's a member of it. Prosecutor essentially alleges that a person is a member of a criminal organization, an enterprise, a gang, an organization that is conducted through a pattern or series of criminal acts, sometimes called racketeering activity. Now, if you can show that somebody is a member of this RICO conspiracy, this criminal organization, they're guilty under the RICO statute and they get a certain number of years in jail. But here's the great thing. You can essentially hold them responsible for all the criminal acts that are committed as part of the conspiracy. I'll give you an example of how this works in practice. Let's say that you're the prosecutor. You see street crime going on in your city. You feel it's gang-related. What do? Well, you could go after the person who just robbed that jewelry store or did that drug transaction, but you feel like even if you succeed and take somebody off the street, well, you know what? Somebody else just replaces them and nothing ever happens. RICO allows you to go after that whole organization. Could be dozens of people, and you go after all of them. And what you do is you say, look, if I can show that somebody's a member of that organization, better yet, if I can show that they're a leader of that organization, that criminal organization, well then, the judge can take into account at sentencing all the criminal acts committed as part of that criminal conspiracy. Let's say the leader of the organization, let's say you're the prosecutor, you don't have a basis for connecting him to a homicide that you think was part of that conspiracy, part of that criminal organization. You can't show that he pulled the trigger. You can't show that he was an accomplice. But if you go under RICO and you can prove that he's the leader of that organization, you're basically going to hold him responsible for that homicide. All of a sudden, he's going to get 20 years, maybe life imprisonment based on that homicide, even though you couldn't have charged him straight up under a murder statute. So that's why prosecutors love to bring RICO charges. And guess what? There are more advantages too. There's some evidentiary advantages. I'm not going to go into that, but here's how it works. The prosecutor goes after the little fish, the guys at the bottom of the food chain. The prosecutor comes to them and says, look, you're going to end up in jail for 20 years if we bring this RICO charge against you. So here's a deal. We're going to give you a plea deal. We're going to offer you a little immunity. And in return, you're going to flip. You're going to become state's evidence. You're going to give testimony against the big fish, the people we really care about, the people at the top of the organization. So all that's been going on in this RICO prosecution of Young Thug. The prosecution says that Young Thug is the leader, indeed founder, of a criminal street gang in Atlanta called YSL. Now, the defense says, well, YSL is not a street gang. That's the name of our record label. But the prosecution says, no, it's a street gang. And he's the leader of it. And we're going to show that he's involved in this criminal conspiracy, this criminal organization, and we're going to hold Young Thug responsible for all these crimes that have been committed. Dozens and dozens of crimes have been committed as part of the conspiracy, including a homicide. So that's what they're trying to do. And yes, indeed, they are trying to flip the lower rung people, try to get them to testify against Young Thug. Now, those are the advantages to the prosecution. But are there any disadvantages? You bet. There's one big disadvantage. A case like that is sprawling. It can be chaotic. You need somebody at the top who really knows what they're doing, or else it can spin out of control. And that's what seems to be happening in this case. I can't tell you how many crazy things have happened in this case. I'm talking about one co-defendant, for example, being stabbed in jail during the middle of the trial. I'm talking about another co-defendant being caught on camera in open court, it seems, doing a drug handoff to Young Thug who's sitting at the defense table. I mean, that kind of stuff's crazy. You've got a Fulton County deputy who was arrested on charges of trying to bring drugs into the courthouse. You got a Fulton County deputy who's believed to be involved in a romantic relationship of some kind with one of the defendants. This is crazy stuff. But the most crazy thing of all is probably what happened just in the last week. The judge sentenced the chief defense counsel to 20 days in jail. What happened there? What are the legal issues? Let me explain. It starts with a witness whose name is Copeland, Kenneth Copeland, aka Little Woody. Now, he's a star witness. He's a key witness for the state. He's one of the people they offered immunity to, and in return, he's going to testify and really nail Young Thug. So last Friday, he gets on the stand, but instead of testifying, he says, I'm pleading the fifth. I'm not going to testify. And the prosecution, they're like, what are you talking about? We had a deal. Mr. Copeland, he says, I'm not testifying. I plead the fifth. And then the judge, Judge Glanville, says, now, Mr. Copeland, hang on. The state has given you immunity. Once a state has given you immunity, they can't use what you say against you, and that means you have no Fifth Amendment right not to testify. You must testify, and if you don't, I'm going to have to send you to jail. And Copeland says, I plead the fifth, I'm not going to testify. And Judge Glanville says, you're going to jail, and they take him away to jail. Okay, so that's last Friday, and then the weekend passes, and on Monday, the prosecution comes in and says, Mr. Copeland, he's ready to testify. We'd like to call him back to the stand. He's going to testify this time. And Young Thug's chief lawyer, Brian Steele, he stands up and says, I move for a mistrial. And Judge Glanville says, on what ground, Mr. Steele, are you moving for a mistrial? And Steele says, on the ground, Your Honor, that you and the prosecution and Mr. Copeland met over the weekend all together outside the presence of defense counsel. You met with a witness and the prosecution, and you didn't tell the defense about it, and that was improper, Your Honor, and I move for a mistrial. Now, the judge, he doesn't deny that the meeting took place. Instead, what he says is, who told you about that meeting? And Steele, he says, I'm not going to answer that question, Your Honor. And the judge says, you better answer, or I'm going to throw you in jail. And Steele says, I'm not answering. And the judge says, well, I'm going to give you some time to think about it, but you better come back here and give me a better answer. And Steele refuses to change his mind. After a recess, he says, I'm not answering. And the judge says, in that case, I'm finding you in criminal contempt of court, and I'm sentencing you to 20 days in jail. And you're going to spend those 20 days on weekends. The next 10 weekends, you're going to spend both Saturday and Sunday in jail. Okay, now this raises a ton of issues. First of all, is it proper for a judge to have a meeting with a witness and the prosecution outside the presence of defense counsel? Well, I'll tell you, any criminal lawyer is going to say to you, that's incredibly irregular. So irregular that it might mean that Steele had a point when he moved for a mistrial. Normally, judges absolutely cannot do that. You can't be meeting with a witness and the prosecution without the defense being represented there. Maybe there was some exceptional circumstance, I don't know, but maybe the prosecution came in and said, we've got some exceptional circumstance, we need to meet with you with this witness, and we can't have defense counsel there. But even so, even if there was something exceptional, probably the judge needed to inform defense counsel that it was happening. Why do I say that? Well, first of all, Georgia procedural rules probably require it. I'm no expert in Georgia procedural rules, but a lot of Georgia lawyers are saying that the judge could not have this meeting ex parte outside the presence of defense counsel. But also, you know what? There's a constitutional issue there. Things that were said at that meeting could possibly have been Brady material. I'm not going to go into what that word Brady refers to, but Brady material is material that the prosecution must constitutionally turn over to the defense. It's possible that there was some Brady material in that meeting. So for either state law reasons or constitutional reasons, it is very dangerous for the judge to be having a meeting with a witness in the prosecution without having defense counsel there. What makes it an even worse look is that he tried to keep the whole thing a secret and didn't even tell defense counsel that the meeting was going to take place or had taken place. So that's a very bad look for the judge. It's a possible mistrial basis in itself. Now, what about when the judge says to the lawyer, I'm throwing you in jail because you're not answering my question? Can a judge do that? Can a judge throw a lawyer in jail for not answering a question? Answer, in theory, yes, he can. A judge can find anybody in contempt, including a lawyer, in contempt if that person violates a valid judicial order. Here, the order was answer my question. The lawyer, Mr. Steele, he refused to answer it, and Judge Glanville said, well, in that case, that's contempt, and I'm sending you to jail. But remember, it has to be a valid judicial order, and that's where questions are going to arise. Being held in criminal contempt, because that's what the judge found Steele guilty of, criminal contempt. As the name implies, criminal contempt. Criminal contempt is basically a crime. You're being found guilty of a crime if you're held in criminal contempt. Now, normally in the United States, a person can't be found guilty of a crime without all kinds of due process protections. That's a constitutional matter. You get a right to a hearing. You get a right to proof beyond a reasonable doubt. You get a right to have a lawyer represent you, call witnesses if you want. But there's one exception where you can be found guilty of a crime without that full panoply of due process protections. Now, I'll bet you most lawyers do not even know of this exception. But you'll know because I'm telling it to you. That exception is criminal contempt, and specifically what's called direct criminal contempt. What's that? That's where you commit that act of contempt in the presence of the judge in open court. That's direct criminal contempt. And the idea there is if the judge sees the act that you're committing and knows it's contempt, well, we can dispense with the due process protections that you otherwise get, and the judge on a summary basis can find you guilty of contempt right then and there and sentence you to jail. Can't sentence you to jail for very long. In Georgia, it's 20 days maximum, and that's what Judge Glanville did with Mr. Steele. But he can still sentence you to jail, found guilty of a crime, and that's an exception to the normal constitutional rule that requires so much due process if you're in danger of being found guilty of a crime. Now, that may make sense or it may not, but that's what the Supreme Court has held for almost a century. But there's a corollary. The Supreme Court says, here's the corollary. The judge has to know, based on what he saw in court, he's got to be sure that every element of the offense is satisfied. He's got to know for sure you committed the offense before you can dispense with all those due process protections. And here, there could be an issue. And that goes back to whether the judge asking him that question and telling him to answer it was a valid order. Why is that questionable? Because a judge cannot ask an attorney to violate attorney-client privilege and then throw him in jail because the attorney refuses to violate that privilege. The judge couldn't say to an attorney, hey, Mr. Attorney, tell me whether your client has told you whether he's guilty or not. I just want to know, tell me. And then if the attorney says, I can't answer that question, the judge can't send him to jail because of that. The attorney in that case has a basis in attorney-client privilege for not answering the question, and therefore the judge can't send him to jail. Problem is, there's no way for Judge Glanville to know for sure whether Mr. Steele had a privileged basis for refusing to answer the question. It could be that by answering the question, he might have violated attorney-client privilege. There was no way for Judge Glanville to know whether he had that basis or not. I'm not saying he did, but I'm saying Judge Glanville couldn't know simply based on what happened in court, whether he did or didn't have that privileged basis for refusing to answer. And therefore, I don't know that Judge Glanville had the constitutional authority to send him to jail without a hearing, the ability for Mr. Steele to put on a little case, to have a lawyer represent him, to call a witness if he needed to explain and show evidence of what his defense might have been. So that makes me a little dubious about this criminal contempt finding entered by the judge. And guess what? The Georgia Supreme Court seems to be dubious too because they have stayed that sentence. Steele appealed and the Georgia Supreme Court said, you know what, we're going to stay that sentence. You don't have to serve those days in jail while we're considering your appeal. My guess is Steele's never going to have to serve that time in jail, but that's just a guess. We'll have to see. Now, I'm going to conclude by stepping back a little bit. What is happening with this case? What do we say about it overall? Well, here's the thing. A massive RICO conspiracy has to be handled very well. Otherwise, you're going to have big trouble. It's like a battleship And you have to have a captain at the helm that can run a tight ship, handle a crew of 400 to 500 people, know what everybody's job is, make sure that everybody does their job in the right order. If you don't have a captain like that at the helm, that ship's going to veer off course shortly after it leaves port. And very soon, it's going to start spinning out of control. And what it looks to me like is you do not have a captain at the helm who's running a tight ship. Now, you know who the captain at the helm of this ship is, or maybe you don't, but I'll tell you. It's Fulton County District Attorney Fani Willis. That's right, that's the same district attorney whose shenanigans may be even crazier than those here, whose shenanigans you've read about in her case against former President Trump. And guess what? That's also a RICO prosecution that probably shouldn't have been brought as a RICO prosecution. So what it's looking like to me, and I don't know all the facts, but what it's looking like to me is that District Attorney Willis is not running a tight ship. She may not be in full control of her office. She does not appear to be in full control of this prosecution. And now they may have gotten the judge in big trouble too. Maybe the prosecution said to the judge, we need you to meet with this witness. Whatever happened, you got the judge in trouble. You got a prosecution whose chief prosecutor, the district attorney, doesn't seem to be in full control of the ship. Bottom line, straight down the middle says, this trial has mistrial written all over it. Well, that's all from me for today. Thanks for watching. Now remember, the Supreme Court's going to start coming down with some very important decisions. First Amendment, presidential immunity, scope of the January 6th prosecutions, all that's coming down very soon, next week or two. And when those cases come down, I'll be doing episodes to try to explain those cases to you as well.
Because the flag still stands for freedom, and they can't take that